Hello, I'm Rashi Goel and I'm legal intern at LEXIS and Company. In this video, I'll be talking about rights which are conferred on mere applying for the registration of trademark and rights which are conferred after the registration of trademark. So first, let's talk about rights which are conferred on mere applying for the registration of trademark. First is it serves as the evidence for the adoption and the solution of trademark of state goods and services. Second is it enjoys the priority against the identical or the similar marks pending registration for the same or the similar goods or services if a similar mark is applied or used after the date of application. This priority of 6 months is applicable to a members of the Paris Convention and WTO countries. And the third and the last is the prevention of filing date within the 6 months of the priority period in all the countries of the Paris Convention and WTO countries, which means that by applying an application in one country, if the applicant choose to make the application in another country, then the other application will be deemed to have been filed in at the earliest date. Next is the right conferred by the registration of trademark. So the first is it confers on the registered proprietor the exclusive right to use the trademark in relation to the goods and services in respect of which trademark is registered. Second is if the trademark consists of several matters, then there is an exclusive right to use the trademark taken as a whole. If the trademark contains a matter common to the trade or is not of a distinctive character, then there shall be no exclusive right in such a part. Third is it entitles the registered proprietor to obtain relief in respect of the infringement of the trademark in a manner provided under the Trademark Act 1999. When a similar mark is used on a same good or a similar good or a dissimilar good or services. Fourth is registration of a trademark which forbids every other person except the registered or unregistered permitted user to use or to obtain the registration of the same trademark or confusingly similar trademark in relation to the same goods or services or the same description of goods or services in relation to which trademark is registered. Fifth is after the registration of the trademark for the goods and services, there shall not be the registered same or the confusingly similar trademark not only for the same goods or services but also in respect of the similar goods and services by the virtue of section 11 subclause 2 of the Trademark Act 1999. Sixth point is moreover after the registration of trademark for the goods or services, there should not be the registered trademark for the same or confusingly similar trademark even in respect of the dissimilar goods or services by the virtue of section 11 subclause 2 of the Trademark Act 1999 in case of well-known trademark. Seventh is registered trademark shall not be used by anyone in business papers in advertising. Incorporate advertising should not take place under the advantage of trademark. Such advertising should be in contrary to the honest practice in the industrial or commercial matters. The advertising should not be determinal or to the distinctive character or the reputation of the trademark. Eighth is there is a right to restrict the import of goods and services which are marked with a trademark similar to one's trademark. Ninth, there is a right to restrain use of trademark as a trademark name or the part of trade name of business concern which is dealing in the same goods or services. Tenth and the last is the registered trademark continues to enjoy all the rights which are vested in an unregistered trademark by registering the proprietor of an unregistered trademark which is converted into the proprietor of the registered mark. An application for the registration may be based on the mark in use for the prior to such application, and such a trademark is already vested with the right at the common law for from the time the use of the mark was commenced. So, getting a trademark registered is a more beneficial. Here, Trademark Act 1999, the main object is to provide for the registration of the trademark and better protection of trademark for the prevention of the use of the fraudulent marks and merchandise. Thank you.